if you recall at the start of this week, we had triggered off a debate on the 3 new criminal laws that have come into effect from the 1st of July. These new laws have replaced the colonial-era legislation like the Indian Penal Code, the Criminal Procedure Code, and the Evidences Act. The Bharatiya Nyaya Sanhita is now being looked at by lawyers very closely. At the start of the week, we had P. Chidambaram, lawyer, politician from the Congress party. Today, we spoke earlier to former Rajya Sabha MP, senior advocate from the BJP side, Mahesh Jethmalani, to understand what he thought, how he saw the key changes in these new criminal laws. Take a look. I want you to first address the criticism that's coming in of the new laws. Many believe they give far too much power to police and therefore they need a review. I'll come to specifics later, but the wider debate, do you believe these new laws are draconian because of the powers they give the police?
Yeah, Rajdeep, from what I've heard is that there's a criticism that this gives excessive power to the police. Yes. And a little unfair to accuse persons. No, that's not really true, Rajdeep. I tell you what the thrust of the changes are. I take it we're now talking about the procedural aspects of the new laws, which is encompassed in the BNSS, the Bharatiya Nagarik Suraksha Sanhita.
Yes.
Because that contains most of the provisions pertaining to procedure. Now, look, frankly speaking, there is no real change. There's just probably one provision which I myself have some, doubts about, right? And that also, it just requires a change of a word. But by and large...
Which provision is that? Which is that provision that you are troubled with?
Well, there's a provision which, deals with custody, custody. The maximum period was police custody of 15 days, right?
That's right.
That's the maximum period you could have for 15. But under the old law, laid down in the judgment called Anupam Kulkarni, right, which held the field for many years. You had to arrest somebody for this maximum period of 15 days within the first 15 period of his arrest, right? Now, the new law, actually, the trend started by Senthil's judgment, which is a very recent judgment, which said there is no reason why this 15-day period should all be within the first 15 days of his arrest. Right? They said can be divided in 2 parts, and they said it can be any time during the period for which his custody is permissible, which is 60 days in the case of some offences and 90 days in the period. So they said you can split it up, right? Now, splitting up the rationale for splitting up was that sometimes you might find evidence later on, not in the first 15 days, right? So you need to take somebody into custody again if custodial interrogation is required. So you can break it up. Now, the present section which deals with this, right, it says it can be done in parts, right? Now, when you say it can be done in parts, it means you could actually arrest somebody for about 15 times if you want to take him into remand for 1 day at a time, right? So you could you could arrest him for a day, release him, and then arrest him again 15 times, technically speaking. Or if you want to do 2 days, you could do it for about 7-8 times. So the in parts should be restricted to 2 parts. That word 2 should be included in that section. I think that's an oversight. If you want to cover that situation where evidence comes later, right? Then certainly you should make it only 2 parts and not make the 15 days total period of police custody over about 5 or 6 times he can be arrested. Mm-hmm. That's the only flaw that I can see. The rest of the Sanhita, the Suraksha Sanhita, is basically geared towards expediting the entire procedure of the criminal justice system, from police investigation to filing of a charge sheet to discharge applications to trials, mm-hmm. and to even to judgments. Even judges have to deliver their judgment within 30 days and not keep it pending forever, or a maximum of 45 in exceptional cases. So that's the main thrust of the Sanhita. The other thing is the extensive use of electronic evidence in every area. So FIRs can be filed electronically. You don't have to go to a police station and file you can do it even on a WhatsApp officer in charge of police station, his number is there. You can file your FIR electronically. And it comes in every stage. You can have every witness now. One of the reasons for trials, it was an endemic reason for delay. And that was witnesses did not show up on the due date, right? There were so many dates when the matters are just adjourned because witnesses were not present. Now you can get witnesses deposing on video conference. So there's a forensic laboratory to be established by every state government, right? You are basically therefore enhancing forensic investigation. You're using audio, video medium for all aspects of trial, right? And not only that, I mean, for instance, now the entire search and seizure process, the entire search has to be compulsorily audio, video recorded. So there can be no planting of narcotics anymore.
But Mr. Jethmalani, you're giving us what you see as the positives in the procedure. You have certain concerns, as many people have, over police custody rules. But let me turn to an area which is again concerning, which is that at a time when the Supreme Court had weighed strongly against sedition, here is the Bharatiya Nyaya Sanhita bringing it through the back door under section 152 and 150. They are bringing back sedition through the back door when it is said that you can criminalize an act which is seen against the sovereignty of the country. It keeps a very wide definition and effectively brings back sedition.
Rajdeep, you see, the difference between the old law and the new law, the new 152, is that the old law, right, it was basically meant to protect our colonial masters, right? Because it's talked about any act which excited disaffection towards the government of the day. So it was government specific. It was not politically neutral. In the case of the colonial masters, I mean, this is an 1860 law, the IPC. So in that case, right, it specifically was meant to protect the British rulers from, disaffection by their subjects, right? Causing disaffection against British rule, in other words. The change is now that it's not the government of the day. So, the government of the day can't take umbrage about any criticism on its own part. And that's why the sedition law was stayed, because not just all governments were guilty about it. I mean, there have been sedition in every state, sedition cases in every state, and the Supreme Court finally stayed it. Now the shift is that you can't have words and actions which tend to undermine the integrity and sovereignty of India. You can't promote subversive activities, and you can't promote secessionism, which I think is unacceptable. These are well-defined words, right?
So another new law, Mr. Jethmalani, which people are concerned about, which says individuals who engage in sexual relations by deceit, such as false promises of employment or marriage without intention to fulfill them, could face imprisonment of up to 10 years accompanied by fines. Many fear this will criminalize even consensual relationships. Are you not worried, again, that laws giving more powers to the police are not good for the country?
Rajdeep, you're talking about now, we've gone from 152 to 69
yes.
of the Sanhita. I take it that's the section you're referring to.
That is right.
Let me tell you, there's a history to this section, right? This is basically the philanderer's nightmare section, which I call it, right? But the fact of the matter is that under the old law, the IPC, the Supreme Court since 2003, right up to 2023, Justice Oak's judgment in the Supreme Court, right, has dealt with these cases, and they've said that if you entice a woman into sexual intercourse on a promise to marry her, it amounts to vitiation of her consent. That means her consent is not truly given. Her consent is given because you have made a false promise to her. So they brought it within the rape law, old section 375, right? And, it did not fit in. It really did not fit in, but they twisted the whole concept of rape to discourage this kind of behavior, that you promise a woman to marry her and then, have sexual intercourse with her. So it was already there. It was already there. Now it's been taken out of rape. And apart from being taken out of the old 375 rape, it's not in the new section 63 of rape. It's a distinct offense, right, under 69. And what has happened is, it's only when the victim of the fraud, the deceit, can prove that he never intended, that the initial promise was at inception never meant to be kept, right? For instance, perhaps if he was a married man and concealed the fact from you, right, then the section would come into operation. Or for some other reason, deceit was practiced on you. But if it's a case where you've had sexual intercourse, right, and you've had a slightly prolonged relationship, this will not apply, and you change your mind. Suppose you did enter into a sexual relationship with the promise to marry, with the intention to marry, right? But subsequently, there's a change of mind either because of parental reasons or for the simple reason that you fall in love with anybody else. Now, that now is not punishable under the new 69.
But
a change of mind, a bona fide change of mind is not punishable under 67.
Okay. Thank you very much, Mahesh Jethmalani, for joining me. Thank you.
Rajdeep. Thank you.